Hey there, parents. Did you know that once your kid reaches 18 years old, you no longer have the authority to make decisions about their health care anymore? Nor will you have access to their financial accounts if something happens to them? We are going to talk about how we as parents can still help our kids when they become adults in the eyes of the law. My name is Sotera Anderson, and I help protect families and their legacies by helping them plan for the unexpected. So you have an 18-year-old, and some colleges are back open, and others will be opening soon. And while estate planning is probably one of the last things that your teenage kid is thinking about, it should be their and your number one priority. Here's why. At 18, they become legal adults in the eyes of the law. So you no longer have the authority to make decisions regarding their health care, nor will you have access to their financial accounts if something happens to them. With you no longer in charge, your young adult will be extremely vulnerable in the event that they become incapacitated. So let's say there's a mishap at a frat party and they lose their ability to make decisions about their own medical care. So seeing that putting a plan in place could literally save their lives, it's your kids, if your kids are already 18 or about to hit that milestone, it's crucial that you discuss and have them sign certain planning documents. The first is a medical power of attorney, which is an advance directive that allows your child to grant you or someone else legal authority to make healthcare decisions on their behalf in the event that they become incapacitated or are unable to make those decisions for themselves. For example, a medical power of attorney would allow you to make decisions about your child's medical treatment if he or she is in a car accident or is hospitalized. Without that medical power of attorney in place, if your child has a serious illness or injury that requires hospitalization and you need access to their medical records to be able to make decisions about their treatment, you would have to actually petition the court to become their legal guardian. And while a parent is typically the court's first choice for guardian, the guardianship process can be slow and expensive. And due to HIPAA laws, once your child becomes 18, no one, not even you as their parent, is legally authorized to access their medical records without their prior written permission. But a properly drafted medical power of attorney will include a signed HIPAA authorization so that you can immediately access their medical records to make informed decisions about their health care. Another document is called a living will. And the living will allows you to make healthcare decisions on your child's behalf during their incapacity. A living will is an advanced directive that provides specific guidance about how your child's medical decisions should be made, particularly at the end of life. So for example, a living will allows your child to let you know if and when they want life support removed, should they require it. In addition to documenting how your child wants their medical care managed, a living will can also include instructions about who should be able to visit them in the hospital, and even what kind of food they should be fed. And so this is especially vital if your child has specific dietary preferences. So for example, if your child is vegan or vegetarian or gluten-free, or they take specific supplements, these things should be noted in their living will. It's also important if you don't know all of their friends or who they would want to be part of their medical decision making. You need this so that they can make decisions, or that you can make decisions on their behalf. Also, you have to remember to speak with your child about the unique medical scenarios, particularly with regard to intubation, ventilators, medical experiments. Another document is a durable financial power of attorney. So should your child become incapacitated, you may need access to manage their finances, and that requires that your child grant you a durable financial power of attorney. It gives you the authority to manage their financial and legal matters, such as paying for their tuition, applying for student loans, managing their bank accounts, collecting government benefits. Without that document, you will have to petition the court to get that authority. And all these documents also provide peace of mind, because as parents, it's normal to experience anxiety as your child becomes an individual, an adult in the world. And, with all the crazy things happening right now in the world, these fears have undoubtedly intensified. So while you can't totally prevent your child from unforeseen illness or injury, with us as your personal legacy lawyer, you can at least be rest assured that if your child ever does need your help, you'll have the legal authority to provide it. So if any of this resonates with you, or if you know that it's going to resonate with someone else, please forward this to them. You just may be saving them from a lot of heartache. Contact us today. See you soon.